Thanks for joining our overview of the fiscal year 2023 H-1B CAP process presented by Chug LLP. Before we get started, please note that this video is only intended as a general overview of the H-1B CAP process. This video does not provide legal advice for your specific case, and it does not create an attorney-client relationship. Please contact your Chug LLP attorney for case-specific questions. We're going to share an overview of the H-1B visa category for those of you who are undergoing the H-1B CAP process for the first time. There are three main requirements for an H-1B visa. First, the job must require at least a bachelor's degree in a specific field. For example, a software engineer position would require at least a minimum of a bachelor's degree in computer science or a related field. Second, the prospective H-1B employee must have the same educational and/or experience background that the job requires. Finally, the sponsoring company must meet Department of Labor regulations related to wages and working conditions. Generally speaking, for any H-1B petition, including CAP subject H-1B petitions, one of the first items to complete is filing the Labor Condition Application, or LCA, with the Department of Labor. In the LCA, the Department of Labor, or DOL, requires that employers pay the H-1B worker the higher of two wages. Number one, the prevailing wage, set by DOL, is the average wage paid to workers in similar jobs in the same geographic area. Number two, the actual wage is what the employer pays to other employees in similar roles at the same location. Both wages are based on the position's metropolitan area. For example, if the position is based in Oakland, California, the wages would be based according to similar occupations in the greater San Francisco area. The employer must pay their H-1B employee the higher of the prevailing wage or the actual wage. So, what does H-1B CAP mean? There is a numerical limit, or cap, to the number of H-1B visas that are available each fiscal year. This cap is set by Congress. Each fiscal year, 85,000 H-1B visas are available, with 20,000 of these reserved for foreign nationals with a U.S. master's degree or higher from a qualifying accredited institution. Normally, there is more demand each year than there are new H-1B visas available. So USCIS runs a randomized lottery to select H-1B registrants. Employers are eligible to file an H-1B petition for individuals that are selected in the lottery. As with previous years, there will be a lottery in 2022. The H-1B lottery is run through an online pre-registration system. This system has not changed from last year. USCIS will open the registration system from March 1, 2022 at 12 p.m. Eastern Time through March 18, 2022 at 12 p.m. Eastern Time. During this time, your employer will register any foreign nationals that they plan to sponsor for a CAP subject H-1B visa. It is important to note that USCIS will automatically disqualify any duplicate registrations filed by the same company for the same individual. Your employer or their respective attorney will register you for the lottery. Therefore, you must not try to register for yourself at any time. USCIS will run the lottery and electronically notify employers of selected cases by March 31st, 2022. Chug LLP will coordinate with your employer to notify you about your selection status. If your case is selected, your employer will have 90 days to file the full H-1B petition on your behalf. H-1B petitions will be due no later than June 30th, 2022. If your case is selected, your employer will work with Chug LLP to prepare the H-1B CAP petition filing. You will be contacted to provide updated documentation, such as pay statements. Chug LLP will file the petition with USCIS and provide updates regarding things like the receipt notice, whether there's a request for further evidence, and of course, the outcome of your case. It is not yet fully known whether premium processing or 2-week expedited service will be available this year. Last year, the option to premium process an H-1B CAP petition was available, but in previous years, USCIS has suspended these services. Our team will let you know if filing with premium processing will be available again this year. An H-1B petition can be filed in one of two ways. The first method is to file with a request for change of status. Chug LLP will request that your H-1B status take effect automatically on October 1st, 2022, if your petition is approved by that time. If your H-1B CAP petition is approved after October 1st, you would enter H-1B status automatically on the date that your petition is approved. Let's say you are in F1 status and your H-1B CAP petition is approved prior to October 1st, 2022. On October 1st, you would automatically have H-1B status in USCIS systems, and you would not need to take any additional action. Change of status is very important for individuals on F1 status who need CAP/GAP work authorization protection. We'll discuss this soon in more detail. To qualify for change of status, you must be physically present in the U.S. when the H-1B CAP petition is filed, and you must remain in the U.S. until the H-1B CAP petition requesting change of status is approved. Leaving the U.S. before USCIS makes a decision on the H-1B CAP petition for change of status will result in a denial for the change of status request. Therefore, in most cases, you should not travel internationally until after October 1st, 2022. This rule can be complex, so please contact your Chug LLP legal professional for specific questions. The second way to obtain an H-1B is called consular notification. This means that your company will ask for your H-1B petition to be approved, but not activated until you take further steps. Once your petition is approved, you would need to travel internationally, apply for and obtain an H-1B visa stamp at a U.S. consular post, and then re-enter the U.S. using your new H-1B visa. Canadian citizens are visa exempt. They can apply directly at the border or through pre-flight inspection for re-entry in H-1B status. If you need to travel abroad while your H-1B CAP petition is pending, you may need to notify the U.S. consulate. If traveling abroad, you must have another underlying visa status that is valid through October 1st or later while your petition is pending approval. Consular notification is also required if you will be outside the U.S. when your H-1B CAP petition is filed, or if you have to depart the U.S. while the H-1B CAP petition remains pending. Based on your specific situation, your Chug LLP attorney and employer will work with you to develop your best strategy and assess any other risks you could have related to international travel. Now, we'll return to our conversation on CAP/GAP. CAP/GAP is designed for individuals in F1 status whose work authorization, whether OPT, optional practical training, or STEM OPT, expires after April 1st, 2022, but before September 30th, 2022. Under CAP/GAP, you can automatically bridge the gap between when your F1 work authorization expires and October 1st if you are selected in the lottery, the H-1B CAP petition filed for you requests a change of status from F1 to H-1B effective October 1st, and this H-1B CAP petition is filed prior to your Employment Authorization Document, or EAD, expiration date. Once your H-1B CAP petition is filed, you would provide your school with the receipt notice. They can then issue you an updated Form I-20 with CAP/GAP endorsement through September 30th. You will receive an additional EAD card, but proof of CAP/GAP comes from the new updated Form I-20 for CAP/GAP endorsement from your school. You do not need to take any additional action to be granted CAP/GAP. However, to become eligible for CAP/GAP, the H-1B CAP petition for you must be filed requesting a change of status, and it must be filed prior to the date your OPT EAD or STEM OPT EAD expires. CAP/GAP is valid through September 30th, 2022. You may still face a gap in work authorization if your H-1B CAP petition is not approved by then. If you are at risk of losing work authorization, your Chug LLP attorney will coordinate with your employer to mitigate the situation. Finally, if your case is not selected in the lottery, please note that this does not mean your case was denied or refused. Moreover, recent history has revealed that USCIS may run a second or even a third lottery later on in the same fiscal year if USCIS determines that they have not received enough CAP-subject H-1B petitions to fill the 85,000 visas available for that particular fiscal year. For example, last year, USCIS ran 2 additional H-1B CAP lottery selections. Ultimately, even if your particular H-1B CAP registration is not selected, it should not impact your eligibility for other U.S. visas in the future. For example, your employer may choose to sponsor you again next year in the H-1B CAP lottery. If this year is your last chance to get an H-1B CAP visa, Chug LLP will work with you and your employer to explore next steps. This could apply to you if, for example, your F1 student work authorization expires this year and you do not have other visa options. Thank you so much for joining us for this H-1B visa CAP overview. We hope this has been helpful, and we look forward to working together. Please contact your Chug LLP immigration professional for further assistance.